Welcome to Prediction News Update. I'm Chris Gerlacher with Prediction News, and we're talking about Nevada today. Kalshi just had its preliminary injunction dissolved, and we're going to talk about what that means, why we care, and whether we're going to the Ninth Circuit, the Supreme Court, and how we might get there. Like this video for more legal analysis. Or subscribe to our YouTube channel at Prediction News, and follow us on X at Prediction News. We're going to go ahead and bring in Daniel Wallach here, our appellate lawyer. And Dan, what happened in Nevada? Why did this ruling come out the way it did?
Well, Judge Gordon, Andrew P. Gordon, who's the chief judge of the U.S. District Court in Nevada, he had signaled which way he was going to rule 2 weeks ago, a little bit over, almost 2 weeks ago, during the oral argument on Nevada's motion to dissolve the preliminary injunction. He said point blank, it was a 3-hour hearing, no more than 3 hours. And he said that he was leaning heavily, not heavily, but he said he was leaning in favor of dissolving the preliminary injunction. And I think the reason why he didn't take it to an absolute statement was that Kalshi and Robinhood's counsel raised a lot of, I wouldn't say new arguments, but they were kind of newly minted arguments that hadn't gotten a sufficient airing in the papers. And I think Judge Gordon wanted to be cautious and careful about how he ruled in order to allow his ultimate decision to be as bulletproof as possible on appellate review. So I think he wanted to dot all of his I's, cross all of his T's. I mean, for example, in the oral argument, the lawyers for Robinhood and Kalshi suggested that to the extent the states have any issues or disputes with anyone, they should be suing the CFTC, and that there's a CFTC provision that allows inaction by the CFTC to be sued upon. So they raised a lot of sort of new twists to previous arguments and newer arguments, and he wanted to get all of his ducks in a row, which it took him almost 2 weeks to do. I think the trigger for his ruling today, though, was last night's firestorm, in which Kalshi and Nevada dropped a joint notice alerting the court that imminent motion practice would be coming up within 24 hours on Kalshi's emergency motion for stay pending appeal, and that Kalshi was not going to wait for a decision in writing from Judge Gordon, because it was concerned, given Nevada's position, that in the event that Judge Gordon dissolved the preliminary injunction, 1 minute later, Nevada would run into state court and pursue civil and criminal sanctions against Kalshi. So Kalshi wanted to have its motion as of record ASAP, and it told the court, we're going to file by 5 p.m. on Tuesday with or without a decision. And I think that may have, I wouldn't say forced the judge's hand, but may have played an accelerating role in ensuring that the decision came out on Tuesday rather than Wednesday.
Why is that a potential accelerant?
Because I don't think the judge wanted to deal with unnecessary or premature motion practice on a stay issue. I think the appropriate time for addressing a stay pending appeal is when the underlying order has been issued. And I think he saw the writing on the wall that now he would have to adjudicate the sort of a conflation or confusion of issues as part of his underlying ruling. I don't think it tipped the scales that markedly, but I had the feeling that after last night's positions asserted by Nevada and by Kalshi, I think the judge was probably going to move his ruling date up or ensure it came out sooner rather than have to deal with other pending motions. Because to have a motion for state pending appeal filed by Kalshi before an appellate ruling is issued, how can you address the likelihood of success on the merits or attack a judge's ruling that hasn't even been issued yet? So I think that might have played some small role in ensuring that the decision came out today, as opposed to subsequent to Kalshi's premature filing of a motion for a stay pending appeal. It simplifies things.
You mentioned that he wanted to maybe bulletproof his opinion for the Ninth Circuit, make sure he had it argued very tightly. How do you think he did?
He did much better than he did in the Crypto.com case, where his ruling on the issue of a swap was kind of narrowly tailored or focused on the words occurrence and event. And he ignored the analysis around what does it mean to be associated with potential economic, commercial, or financial consequences. He did a partial analysis on the swaps issue in the crypto.com case and concluded that the occurrence or the event at issue, the occurrence or non-occurrence of the event is whether or not the sporting event occurs, not who wins or loses the sporting event. Well, that's only one side of the coin or one half of the definition of a swap. The other component part is whether there are financial, commercial, or economic consequences, potential consequences associated with the occurrence or non-occurrence of the event. So we closed the loop today and came up with an interesting approach to dealing with potential economic consequences. He interpreted that phrase to mean directly associated with, directly tethered to the event itself, not the downstream economic consequences that would benefit non-parties and television networks and other people who may have bet on the game. I mean, because under the latter approach, he was concerned that there would be no limiting principle, that you could have economic consequences associated with almost anything in life. And he wanted to, or his approach to that phrase was to tether it and connect it specifically and directly to the underlying sporting event, as opposed to any of the ancillary things that occur as a consequence of the sporting event.
Very good. And now that he's dissolved this injunction and we're fighting over a stay, I mean, what are the both sides' merits here? What are Kalshi's arguments for getting a stay pending appeal? What are the state of Nevada's for not granting one?
Well, I mean, Judge Gordon may have given Kalshi a little bit of a helping hand by allowing that there are serious legal questions going to the merits, and that this is a nuanced, novel, complex area of the law that's evolving. And he highlighted the fact that the Third Circuit has taken the case under review, and the Fourth Circuit has taken the case under review. And he said these are close questions. He didn't call it close questions, but he said serious legal questions, which is the term of art that the Ninth Circuit uses in determining, in some circumstances, whether to grant a stay pending appeal. I mean, the standard for getting a stay pending appeal is pretty stringent. It's like almost tantamount to getting the preliminary injunction. I mean, you have to show, at least with respect to a stay, you have to show a strong likelihood of success on the merits. You have to make a strong case that you're likely to succeed. You have to have irreparable harm, and also have to demonstrate that it would be in the public interest and that there wouldn't be substantial harm inflicted on other parties to the proceeding, which is why the involvement of the Nevada Resort Association could be so critical to the stay motion, because the Nevada Resort Association represents all of the state licensed casinos whose sports books are potentially adversely impacted by the offering of sports event contracts in Nevada, and the harm that would befall these casino sports books would fit neatly under the third factor of the preliminary of the stay pending appeal test, which is examining whether there are substantial impacts on other parties to the proceeding. But the guts of a motion for stay pending appeal are going to hinge on the likelihood of success on the merits and the irreparable harm that Kalshi would face. And there's a sliding scale approach taken by Ninth Circuit federal courts. If you can't demonstrate or can't make a strong showing of a likelihood of success, you could get by with a lesser showing, such as that there are serious legal questions on the merits, provided that you pair it with a heightened showing on the balancing of the equities. And you'd have to demonstrate that even where there were even on serious legal questions, that's not enough to get over the hump in the Ninth Circuit. The moving party, in this case, Kalshi, would have to demonstrate that the balance of hardships, quote unquote, tips sharply in the moving party's favor. And Judge Gordon's analysis found that while there are serious legal questions going to the merits, the balance of the hardships did not tip sharply in Kalshi's favor, because Kalshi could comply with the state licensing requirements. Kalshi could do what some of the other DCMs are doing, such as Crypto.com, which is excluding Nevada residents. DraftKings, FanDuel, and the other OSB operators that jump into the prediction markets are probably going to be geolocating. And he contrasted that with the harm that would result to Nevada's regulated gaming industry. And under his analysis, the harm suffered by Nevada's gaming interests would outweigh whatever harm Kalshi suffered. So I wouldn't take Judge Gordon's serious legal questions quote as an indicator that he's going to give Kalshi a stay pending appeal. But I think he did set Kalshi up nicely to satisfy that first prong of that two-part sliding test. And now it's incumbent upon Kalshi to convince Judge Gordon, who has already held that the balance of hardships does not tip sharply in Kalshi's favor. Kalshi is now going to have to prove to him that it in fact does, which seems like an uphill battle. And I would expect Judge Gordon not to grant Kalshi's emergency motion for a stay pending appeal. So I think that this ultimately kicks things up to the Ninth Circuit potentially as early as next week. In order to file a motion for a stay pending appeal with the Ninth Circuit, you've got to ask the district court judge to grant it first. It's almost like a prerequisite. You can't ask the appellate court to do something like that without already exhausting your remedy before the district court. And there are instances in which district courts will rule against a moving party on the merits, but still grant it a stay pending appeal. And I think Kalshi is depending on those limited cases or those limited circumstances in granting the stay. But I think this is going to go to the Ninth Circuit.
So how soon, you said that we could end up at some early Ninth Circuit steps as early as next week. Are we expecting Judge Gordon to grant or deny the stay this week?
That might be too soon. He's already heard from Kalshi, so he could deny the stay without hearing from Nevada. I don't think he can grant the stay without hearing from Nevada. So it depends which way he's decisively leaning. And since he's already on record as concluding that Kalshi's balancing of hardships is not tipped sharply in its favor and is outweighed by the hardships faced by Nevada's gaming industry, I think he's already tipped his hand on how he would rule under the Ninth Circuit legal standard, but you never know. So a denial of the motion for a stay pending appeal can be granted without hearing from Nevada. But I would suspect that given that this is an emergency motion, if Judge Gordon hasn't already ordered an expedited briefing schedule, I think Nevada's very seasoned outside counsel of Mayor Brown will be in a position to turn this around and file an opposition brief, no later than tomorrow.
As we move into next week, or even the next few weeks, if Kalshi does not get this stay, how soon do they have to begin geofencing in Nevada?
Not right away. They still have two more bites at the proverbial apple, or two more proverbial bites at the apple. If the district court denies Kalshi's motion for an emergency stay pending appeal, the next step would be for Kalshi to present the same motion to the Ninth Circuit U.S. Court of Appeals. But in order to do that, Kalshi would have to also preface that with a notice of appeal. And as of tonight, when we're recording this podcast, Kalshi has not yet filed its notice of appeal, but that's a one-pager. And once the judge denies the stay motion, if he denies the stay motion, it has 30 days to file a notice of appeal and can then pair that with an emergency motion for stay pending appeal. But Kalshi's not going to wait 30 days. Their concern is that in the absence of an injunction or in the absence of a stay, even giving the state of Nevada 1 minute of a head start will be enough to make Kalshi feel vulnerable to potential civil or criminal enforcement proceedings. So they don't want to have any exposure here, even for a minute or a day. And if, I would think that Kalshi is going to file its notice of appeal within the next 24 hours. Their spokesperson has sort of equivocated that they haven't made a decision yet, but they're appealing, just like Crypto.com filed a notice of appeal. There's no question about it. And I think the notice of appeal will be filed within the next 24 hours. And once Judge Gordon if he denies Kalshi's motion for an emergency stay, 1 second later, Kalshi will be in the Ninth Circuit filing its nearly identical motion for a stay pending appeal. I mean, they can't not appeal. I mean, Crypto.com is taking an appeal. And these appeals, while they're not formally expedited based on the party's request, because it's an appeal of a preliminary injunction ruling, those types of appeals are ordinarily expedited in the Ninth Circuit, which is why the original Crypto.com briefing schedule had Crypto.com's opening brief due in about 2 weeks.
Mhm.
So there will likely be a similar expedited briefing schedule that would be interrupted only by the prospects of emergency motion practice sort of taking center stage before the parties turn to briefing the merits of their appeal.
Is there a Supreme Court shadow docket scenario here for a stay this early?
I think so, but it would require the district court to deny the motion. It would require the Ninth Circuit to deny the motion, as well as Kalshi having already filed a notice of appeal. At that point, with 2 straight denials and an appeal pending in the Ninth Circuit U.S. Court of Appeals, there are occasions where litigants go to the U.S. Supreme Court long before an actual Supreme Court case is ever filed and present an emergency motion for a stay pending appeal based on the representation that there's a Ninth Circuit appeal already pending, and that the parties intend, or that if unsuccessful, the moving party will present a petition for writ of certiorari to the U.S. Supreme Court. So I've come across some precedent or some orders from the U.S. Supreme Court justices where they've granted stays pending appeal, even though the case was still pending at the U.S. Court of Appeals and was probably weeks, if not months away from being presented to the U.S. Supreme Court by way of a petition for writ of certiorari. These are not granted readily or easily. These are sparingly and rarely granted. And at least at the Supreme Court level, you could have one justice deciding the fate of an emergency motion for a stay pending appeal. And it's usually the circuit justice who decides those motions. And I'm going to have to come back. We're going to have to stop the tape and I have to look up who the Ninth Circuit U.S. Supreme Court acting justice is. But that justice will likely be the determinant of whether or not a shadow docket stay motion gets granted. Although in many cases, the circuit justice will refer the motion to the entire court. And that happened in the West Flagler versus Hallen case, where I think it was John Roberts, who was the circuit justice from the D.C. Circuit. And when West Flagler had sought an emergency injunction or an emergency stay pending appeal to prevent the Seminole Tribe of Florida from launching their online sports book, Justice Roberts referred the motion to the entire court, and the entire court issued an unsigned order denying West Flagler's motion for a stay pending appeal. And that order was dissented to by Associate Justice Brett Kavanaugh, who believed that the Seminole Tribe's compacts, which provided the provisions of the compact, which allowed for gaming off of Indian lands via online sports books, violated the provisions of the Indian Gaming Regulatory Act. So in some cases, the early stage shadow docket orders can be a window into how some of the justices are thinking about the case. But to get a denial or grant, the threshold for getting a cert grant, to get the underlying case heard by the Supreme Court, you need 4 out of 9 justices, less than a majority. To get a stay pending appeal, you need a majority, 5 out of 9. So the threshold for getting a SCOTUS stay pre-cert filing is a little bit higher than getting cert granted, and cert grants are few and far between. Fewer than 2% of all Supreme Court petitions for writ of certiorari are granted by the High Court. But this is a case that has potential nationwide importance. It has involvement with the financial markets, involves a federal agency, and there's already a divergence of viewpoints among the lower federal courts. So perhaps it is a case in which the Supreme Court would be willing to grant a stay pending appeal. And if the court did that in the Nevada case, it would likely do that in every other case.
Google is telling me that Elena Kagan is the circuit justice for the Ninth Circuit. Does that tell you anything about the odds of ending up on the shadow docket or not?
Oh, well, she's a Yankees fan. I'm surprised she got stuck in Southern California where the Dodgers play. This must come as unwelcome news to her. Let's see, how would Justice Kagan view this? Hard to say. She's appointed by Bill Clinton. The concern among many people who support or oppose prediction markets is that a Trump influenced court, Republican justices would probably much more likely side with what the Trump administration wants to see happen. So I suppose there is some neutrality here and that Justice Kagan wouldn't be affected by those outside influences. But on the other hand, Judge Keel in the New Jersey federal court was a Democratic presidential appointee, and he ruled in favor of Kalshi. So I'd have to examine Justice Kagan's rulings more closely on that. But she does have some experience with gaming. She heard or wrote the majority opinion in Michigan versus Bay Mills, which is the leading U.S. Supreme Court case interpreting the parameters of the Indian Gaming Regulatory Act and what does it mean for gaming to be on Indian lands and where does the gaming activity take place. These are themes and these are issues which are also somewhat common to the prediction market. So perhaps she's best suited among all the Supreme Court justices to weigh in on this issue. And she's also one of the justices who sat on the Murphy versus NCAA decision. So she's a veteran of two major gaming cases coming out of the high court.
So she's got the background to look at prediction markets and gaming and these interrelated issues.
Yep, and sports betting. And the point that I've kept going back to on prior podcasts is the argument for federal preemption that Kalshi has raised seriatim in all these different legal proceedings has essentially been that the 2010 Dodd-Frank amendments author or granted the CFTC exclusive jurisdiction over swaps, which are broadly defined to include sports event contracts. That's Kalshi's argument, and I think it would come as a little bit of a shock to any justice who sat on the Murphy versus NCAA case to learn that there was already a federal regulatory scheme in place that would allow for sports betting or sports event contracts on CFTC regulated markets. Had that argument been made in Murphy versus NCAA, the outcome of the case may have been different. And maybe there wouldn't be any state legalized sports betting in the aftermath, because the linchpin of the Murphy ruling is that Congress was commandeering the states by prohibiting states from regulating or authorizing sports betting without supplying a federal scheme of regulation or deregulation. And the absence of such a federal regulatory scheme made PASPA an unconstitutional federal statute. Had Milbank been around in 2017 to advance that argument before SCOTUS and Murphy, the outcome probably would have been different.
There's one reaction to the Nevada PI dissolution that I want to really ask you about.
Wait a second. I want to correct my other answer. The outcome wouldn't have been different. That would have been laughed out of court in 2017.
Milbank would not have changed the minds of the NCAA.
No, absolutely not. But the whole premise of the federal preemption argument depends on the existence of a federal regulatory scheme for sports event contracts that dates back to the 2010 Dodd-Frank amendments. And the Supreme Court, hearing the PASPA challenge in 2017, wasn't told anything about Dodd-Frank, not by the sports leagues, not by the federal government, not by the state of New Jersey, and not by the multiple amici curiae that participated in the Murphy versus NCAA Supreme Court briefing. So it would have been a revelation to everybody involved in that case that there was this regulatory scheme in effect back in 2017.
Closed the loop perfectly. Let me ask you about something that's going around in the commentariat tonight.
The commentariat? What is it?
The commentariat?
It's commentariat or commentaria?
Commentariat.
I like that.
I don't remember who I stole that word from, but I also saw it and thought it's super useful, so I'm using it now. There's this idea that, it's kind of over for Kalshi. They have to pull out of Nevada altogether. You're already shaking your head. What is the response to that line of argument that's going viral tonight?
Well, to be fair here, I've got to look at it, and just remind people that we're not at the 8th or 9th inning yet. Just as Kalshi had gotten off to a spectacular start by securing 2 preliminary injunctions in Nevada and New Jersey. And I was on the podcast and analogizing this to a 9-inning game. We're only in the 2nd inning. Well, now the states have basically roughed up Kalshi's starting pitcher and racked up wins in Maryland, Massachusetts, Nevada in the crypto case, and Nevada in the Kalshi case. So that's 4 consecutive rulings coming out of the federal courts rejecting Kalshi's federal preemption argument, although the Massachusetts ruling was rejecting a complete federal preemption argument, which is a subtle difference, but still 4 consecutive rulings favoring the state. So this is basically the third, fourth, and top of the fifth inning. I would say third and fourth inning in which the states are roughing up Kalshi's starting pitcher. And until the federal courts of appeal begin weighing in, it's almost, to use another sports analogy, a playoff series doesn't start until a home team loses its first game. And until we get a federal court of appeals decision, especially on issues that involve pure statutory interpretation, questions of law, de novo review, who's to say how the third? I think I know how the Third Circuit will likely rule and come out in Kalshi's favor. But until the oral arguments are held in the Fourth Circuit in Maryland, the Ninth Circuit in San Francisco, and the Sixth Circuit with Ohio, the Second Circuit in New York, for those future appellate cases, that's when the rubber meets the road. And right now we just have district court decisions that are going terribly for Kalshi. But it's still the fourth inning, and there's a lot of runway left. No federal appeals court has weighed in, and if there's any divergence among the federal court of appeals opinion, we're likely headed to SCOTUS. So it's a long game, and you can't. It's just like there are momentum shifts in playoff series. This is a clear momentum shift, and I think the momentum will be in the state's favor for a little while longer. But again, I remind you, these are issues of law, questions of law that judges in different courts can disagree upon, and the appellate courts owe no deference to the interpretations of statutes given by district court judges. So it's a brand new ball game when you get to the circuit courts.
Well, I wanted to ask you about exactly that. As we get these district cases that go up to the appellate level, the appellate courts can say, hey, I don't like your legal reasoning, adjust. What are the odds you think we begin to see some shift, either continued in the state's favor or back toward Kalshi's favor at the appellate level due to what appellate courts may view as flawed legal reasoning?
Well, we don't have to wait for the appellate ruling on the merits a year from now. The emergency motion practice that will formulate around Kalshi's Nevada contracts will key in on the likelihood of success on the merits. And in order for the Ninth Circuit, if it gets to the Ninth Circuit on an emergency motion, the Ninth Circuit's granting of Kalshi's motion for a stay pending appeal could be an early window into how the Ninth Circuit views the merits of the appeal. Of course, if it grants the stay based upon serious legal questions being presented, along with a heightened balancing of the harms, that doesn't necessarily mean that the court will side with Kalshi on the underlying appeal. It just means that Kalshi will get a stay until the appellate court can decide the merits. But as early as next month, we could have Ninth Circuit orders, a Ninth Circuit order in the Kalshi case, giving some early preview, a sneak preview or a sneak peek into how the Ninth Circuit views the merits of Kalshi's appeal, and because of the similarities in the merits and the likelihood of success on the merits on a PI, there's going to be some overlap, and the court will necessarily, sort of touch on the merits of Kalshi's legal argument. So I'm not saying it's a guaranteed predictor, but it is an early predictor and an early preview of how the court may come out on the issue. And it's no guarantee because I go back to the West Flagler versus Howland case. The Seminole Tribe prevailed on the merits of the appeal before the DC Circuit, but were unsuccessful in getting they were unsuccessful in prevailing on their motion for a stay of the lower court judgment pending appeal. The lower court in the DC District Court had held that the Seminole Tribe's online sports bets through the compact violated the Indian Gaming Regulatory Act. The Seminole Tribe immediately appealed, sought stay relief or denied stay relief, and then won on the merits. So it can go, just because the stay is denied doesn't mean you can't win on the merits. And on the flip side, even if you secure a stay pending appeal, that does not necessarily mean you're going to win on the merits, but at least it's some reasoning and it's some early indicator of how the Ninth Circuit may view the case.
I love the holiday drama. Dan, we've covered a lot of ground today. Is there any final thought that we need to know about the Nevada decision or what we've got coming up next before we sign off?
I think the downstream impacts of this court ruling, if it holds, even if it doesn't hold, now that the states have won 4 consecutive decisions on the federal preemption issue, I think we've got to start looking to 2 possible after effects or aftershocks, one of which will be the possibility of other states getting involved in litigation with Kalshi, Robinhood, and or Crypto.com, and who knows, maybe Polymarket, maybe the Chicago Mercantile Exchange. But I have eyes pointed on Arizona. And now that we have 2 federal district court decisions coming out of a 9th Circuit lower federal district court, that's the only precedent addressing the question of whether the Commodity Exchange Act displaces state sports betting laws. It's favorable precedent for other states that are within the 9th Circuit, and that would be Arizona, Oregon, Washington State, and potentially California. California, I think, is the only one of those states that does not have a regulated sports betting market, but Arizona has previously issued cease and desist letters to Kalshi and has issued warning notices to its licensed gaming operators to stay out of prediction markets. And this second ruling coming out today that favors the states within the 9th Circuit could be the impetus for a state like Arizona becoming the 7th state to be in litigation with Kalshi. And I would not overlook the possibility of the California Indian tribes pushing the state attorney general of California to file a similar lawsuit. But until now, or at least to date, there have been no lawsuits involving states without regulated sports betting. They've entirely been 7 out of 7 states that issue licenses for sports betting that have pointed to the absence of any licensing by Kalshi. So if California were to be a litigant, it would be the first state to do so without a regulated sports betting framework. But given the influence and the lobbying prowess of the California Indian tribes, along with the very flexible California state statute that allows any county, city, or district attorney to bring a civil enforcement action on behalf of the people of California, provided that there are certain population thresholds that are exceeded. Basically, the Los Angeles city attorney, the San Diego city attorney, the big cities, the big counties, their city and county attorneys have standing to bring these kinds of lawsuits against Kalshi under California's unfair competition law. So I think the 9th Circuit could soon become a hotspot for the prediction markets if other states begin weighing in, like Arizona, Oregon, or potentially even California.
Stakes just keep getting higher and higher in these cases. But Dan, thanks so much for breaking all this down for us. If you're here, like this video to see more of these types of interviews. Subscribe to our YouTube channel at Prediction News and follow us on X at Prediction News. Dan, man, we're all going to be watching you follow these cases. Remind us where we can follow you.
Wallach Legal on X and Daniel Wallach on LinkedIn. Sports Gaming Law is my website, sportsgaminglaw.com. You can shoot me an email, and my email address is kind of public record, no big secret. WallachLegal@gmail.com, and we're going to see each other next. Hopefully, it's December 9th, when the Massachusetts Superior Court in Suffolk County hears the Commonwealth of Massachusetts' emergency motion, their own emergency motion for a preliminary injunction, based on Kalshi not complying with state licensing requirements. So I think that's the next big showdown, along with the emergency motions that have been filed by Kalshi or will soon be filed with Kalshi. So we're about to enter a very vibrant period with a lot of judicial activity. We're going to have a Nevada ruling, a potential 9th Circuit ruling on the emergency motion, a Massachusetts ruling, and then preliminary injunction hearings that will soon be scheduled in Ohio and New York. And by the middle of January, we could have a few more rulings that can help maybe bring greater clarity, if not 100% clarity, at least greater clarity to sports prediction markets. So that's what's on tap between now and the beginning of the new year.
Just in time for the holidays. Well, happy Thanksgiving, Dan.
Chris, the best to you and your family, and to the entire Prediction Markets family, and to our producer Spencer. I love doing these, and these podcasts have been very, very fun, a lot of fun for me, because they keep me on my feet. So everyone in the audience, I wish you have a happy and healthy Thanksgiving, and we'll see you again soon.